Theosophy is a fringe religion invented in New York in 1875, which still exists in Australia today. It was briefly popular in the late 19th century, and in 1911 a perpetual lease of land was granted by the South Australian government to the southern centre of Theosophy. The leasehold area was bordered on one side by Lake George, a large lake, officially an inland lake, but it's really only separated from the Great Australian Bight by the narrowest strip of land. 2 years later, in 1913, a channel was cut between the lake and the sea, and this caused a number of unintended consequences. For one thing, the lake began to be affected by tides and tidal movement of silt and dirt. At the same time, winds began to blow other silt and dirt onto the same area. Over the decades, an area of no less than 20 acres was added between the original bounds of the lease and the actual lakefront. Under the doctrine of accretion, where the shape of the land changes in this way, the additional land goes to the receiving landholder. The Theosophy Centre applied to have it recognised that the additional 20 acres fell within the boundary of its perpetual lease. The South Australian government opposed the application. The sticking point seems to have been that even though the lease clearly described the boundary as being the shoreline of the lake, an official map had been drawn up which drew in a boundary on the lakeside, and the state argued that this line was the official border. The matter ended up in the Privy Council in London, one of the very last Privy Council appeals before they ended in 1986. Lord Wilberforce, for the court, found that the doctrine of accretion continued to apply despite the map, which was merely an administrative process. He said the doctrine of accretion gives recognition to the fact that where land is bounded by water, the forces of nature are likely to cause changes in the boundary between the land and the water. Where these changes are gradual and imperceptible, the law considers the title to the land as applicable to the land, as it may be so changed from time to time. This may be said to be based on grounds of convenience and fairness. This case provides a modern and Australian confirmation of the doctrine of accretion.